Welcome to the 4th V.S. Mallar Memorial Legal Aid Competition podcast, an initiative of JSS Law School Autonomous Mysuru and the Center for Environmental Law Education Research and Advocacy at the National Law School of India, University, Bangalore, in collaboration with the Department of Justice, Government of India. Under the theme Freedom from Violence, Legal Provisions for Safety and Security of Women. This podcast series seeks to translate legal knowledge into accessible community level awareness.
Our audience today includes PRI members, ASHA workers, teachers, Anganwadi staff, and community leaders. These individuals are often the first to notice distress in a child or receive a disclosure of abuse. This episode examines a critical but frequently overlooked dimension of child protection under the POCSO Act. The gap between legal provisions and their lived implementation at the community level. Despite a robust statutory framework, many cases falter due to fear, social pressure, stigma, and lack of sustained support for children and their families. We will explore why community level actors are central to prevention and response, the real challenges families face in pursuing justice, and the practical shifts needed at the grassroots level, which are supported by the state, judiciary, and civil society. To ensure that POCSO truly works for every child across gender, caste, and social context.
To help us unpack these complex issues with depth and clarity, we are honored to host Dr. Professor Asha Bajpai, a pioneering expert in child rights and access to justice. With over 4 decades of experience at the intersection of law, policy, research, and grassroots commitment, she has shaped India's legal landscape through her work at NLSIU, her leadership as former founding dean at TIS's School of Law, and her field action projects such as Project Chunoti and Project Access to Justice. Her expertise has guided national and international reforms through roles with NALSA, NHRC, UNESCO, UNODC, and UN Women. She holds an MPhil and a PhD in law and has also served as a Fulbright lecturer at the Washington College of Law, Washington, D.C. She has also been a scholar in resident at Missouri Western State University. In addition to her academic and policy work, she is a widely published author with notable work including Child Rights in India, Law, Policy and Practice, Oxford University Press, now in its third edition. From Exploitation to Empowerment and Adoption Law and Justice to the Child. Her scholarship, including Child Rights in India and From Exploitation to Empowerment, continues to inform practitioners, policymakers, and community workers nationwide.
It is a privilege to have her with us today to discuss how we can strengthen child protection systems, support vulnerable survivors, and ensure that POCSO delivers justice, not just in law, but in practice. Dr. Bajpai, welcome.
Thank you, Krish, and thank you, Omkar. And I would at the outset like to thank Symbiosis Law School for inviting me here for this very important awareness session. You may continue.
Dr. Bajpai, to begin with, could you describe how law and policy actually affect children and teenage girls in rural India when they are subjected to sexual violence?
We have the Protection of Children from Sexual Offences Act, known as POCSO, that you mentioned, which promises children that they will get justice, and it is an act which provides child friendly procedures, and it gives to give evidence so that their trauma is reduced. It is a gender neutral law for both boys and girls throughout the country, including rural areas, and there is a need for awareness of these laws in the rural area, so that all people are aware of this child friendly legislation that has come for children, and it sees to it that children are not traumatized in courts right from the time of the complaint is filed or the FIR is filed till the judgment is there, till the end. There are very child friendly procedures everywhere, and they have to take the interview of a child in a place in which the child is comfortable with, and then they have to be very the questions do not have to be very intimidating. then there has to be a lot of confidentiality. And also there is the fact that there is mandatory reporting under the law. Mandatory reporting means that in case someone comes to know that a child is being abused, or there is a possibility that the child may be abused, the person has to report. So, these are some of the features of the POCSO law that is there, so that children are very comfortable in giving evidence, in going to the court, and in the court also when they stand there and give their evidence. It is supposed to be a very child friendly court, not that usual court where the judge is at a higher pedestal and the child is down on a box. No, it is not like that, and the evidence is taken through CCTV cameras, so that the child does not face the abuser in any way, and the questions are asked through the judge and not directly by the opposite lawyer.
Now, moving on to the next question. ASHA workers, teachers, Anganwadi staff and PRI members are often the first to notice behavioral changes in a child or receive a disclosure of abuse. From your experience, why is the role of community level actors so critical in prevention of and response to sexual violence against children under the POCSO framework?
ASHA workers, Panchayat Raj representatives and Anganwadi workers are frontline workers. So, what happens is they know what is happening throughout in the community where they are from, and the community knows them, accepts them, is aware of them. So, what happens is in case there is a case of child abuse, they are the first ones to know, because they see the behavioral changes in a child. So, when they see this, they can come to something somewhere is wrong, something somewhere is wrong, and maybe they can try to find out if the child is close to them, or maybe they can ask the person who is close to the child to find out what is wrong with the child. And I feel the ASHA workers, Anganwadi workers and Panchayat Raj representatives can be those trusting adults in case they form a build a rapport with the child, and the child can maybe reveal to them if the child is scared of revealing to anybody. These abusers are mostly those people who are known to the child. So, the child is scared that nobody is going to believe them, and that is why they do not say. It is very difficult for the child to understand that this is abuse. I have come across a case in which one child who was abused by the own caretaker felt that that was not abuse, that was love. So, they can't understand what is happening to them. So, that is why Anganwadi workers, ASHA workers, PRI workers are very important bridges with the children, with the family, with the community, with the administration, who can help find out what is happening and help the child feel comfortable. But these people need to be trained.
Yes,
These people need to be trained. They should know what POCSO is about, what are the structures under POCSO, what is the feature of POCSO, and whom they can go to, child welfare committee, they can go to legal services authorities. So, they should know who these structures are, where are they, who are the NGOs. I remember I had done a training program for Anganwadi workers and ASHA workers some years back. And after the training program, the comments that I got from these feedback that I got from these participants who came there was that we are far more empowered now, because they understood what POCSO and other constitution and all laws are about. So, it is important that we train them, empower them with all this, and they could be a good asset to the rural community.
Right, ma'am. Definitely, ma'am. So, ma'am, building on that, your work with survivors and families gives you deep insight into what happens after disclosure is made. In your assessment, what are the most critical gaps, legal, psychological, financial, or social, that prevent families from standing by their child and pursuing justice under POCSO?
Many families have to stand by the child. They know the abuse has taken place, and many families do not stand by the child, not because the abuse has taken place or not taken place. They do not stand because for them survival is more important. If their livelihood depends on that, or if their future work, food, everything, ration depends on that, then in that case they are scared to come out, and they are scared to come out because for them food, livelihood is more important than going to the court and getting justice for the child. So, that is why many times they do not stand by it, and many times they also feel this, they feel that my child may be imagining, because how can someone close, someone relative, I mean very close, a relation of the child who are our relatives, what will they think if we talk about them in public. So, I have noticed in rural areas many times, even today, caste plays a very important role in rural areas, and if a person even goes, suppose they want to go to the court, to the police station first, that and file an FIR that my child is abused. Many times if the maybe the abuser is of a different higher caste, then or in a different higher position in the village, then in that case there is a delay in filing the FIR. The investigation is also delayed. So, all these factors, the poor child is under a lot of pressure. So, the child does not say anything at all. There are support persons under the law. The law says that child welfare committee will appoint a support person, which is mandatory under law, and if you do not appoint a support person, you have to give in writing with reasons why you do not want a support person. But in spite of all that, it is finally the child who has to talk against someone whom you love, who you had loved and you had respected, because I said majority of them are close to the child, they are the abusers, and that is why it is a difficult thing for the child to say in this. So, it many times I have noticed that in the they do not say a word against the person in front of them, and also though there are child friendly courts, the abuser is not facing the child is supposed to be in a different room. There are evidence taken through CCTV cameras, or through in some courts when there are no CCTV cameras there, but in those districts where those such centers are not there, or vulnerable witness courts, what happens is that the judges are trained to see that they convert their chambers into vulnerable witness deposition center. So, what they do is they call the lawyer, the prosecutor, the child and someone close to the child in their chambers, and in the chambers they take evidence and not direct questions. They are given in a sealed envelope beforehand to the presiding officer or the judge, and they ask the questions.
Ma'am, following up on the same,
Yeah.
as you explained, there's a growing emphasis on trauma-informed justice
Yeah.
and directions of trauma-informed spaces in every district court. However, most district courts lack trauma-informed spaces. So, how can judges, prosecutors, defense attorneys be trained to create a POCSO courtroom that is genuinely trauma-informed from the opening statement to cross-examination?
Yes, as I mentioned to you, there are vulnerable witness deposition centers. They started in 2022 after a Supreme Court judgment. So, the Supreme Court had said that all courts must have vulnerable witness deposition centers for vulnerable witnesses like children and mentally ill and women, so that against violence. So, but as I mentioned to you, in those courts where till today there are no such centers, the judges' chambers have been converted into trauma reducing centers, so that where evidence is taken in this manner, as I mentioned to you, by the judge in the chamber of the judge. And judicial academies have included the child psychology, child rights, how to take evidence of a court of a child, sorry, how to take evidence of a child. All these are taken by trained in the judicial academies today.
Ma'am, taking up a new topic, a critical statistic emerges when we examine cases with hostile witnesses. In 2,143 cases with hostile witnesses, It resulted in an 86.4% acquittal rate. What's your take on what these figures reveal about systematic gaps in safeguarding child witnesses from pressure, intimidation, and trauma?
As I earlier mentioned to you that for a child it is very difficult to give evidence in the court. Because of this mandatory reporting, what is happening is, in our country mandatory reporting has been given to everybody, all adults, even children can report on their own. But what is that in many other countries, mandatory reporting is only for certain trained people like doctors, nurses, teachers. They are trained first in mandatory reporting. But here, since everybody and anybody can do mandatory reporting, this we need to reconsider this mandatory reporting aspect. That we should we the objective of mandatory reporting, I agree, was very good.
Yes, ma'am.
That if you report, people never used to report, but if you report, then the person is caught and he doesn't go around or she doesn't go around abusing other children. That was the objective of mandatory reporting. But if it is made to everybody who is not aware of what is POCSO, then in that case it becomes very difficult, this mandatory. So, we need to reconsider the mandatory reporting. So, one is about mandatory reporting,
Yes,
you
ma'am.
need to look at relook at that aspect of mandatory reporting. And the second thing in POCSO that I would like to say is that we have this 16 to 18 years youngsters,
ma'am.
teenagers, who and the POCSO does not distinguish between exploitative and non-exploitative affairs or sexual intercourse between or sexual relations between the 16 to 18-year-old. It is not distinguishing. Today in courts there are 27%, at least almost studies have shown that 27% cases of these 16 to 18-year-old, they are in a relationship of their own free consent. But because they come 18-year is the age under which a child is considered as a vulnerable under POCSO Act. So, if the 16 to 18-year, they have a sexual relation which is now common today. So, that comes under POCSO. So, what is happening is that they are 16 to 18-year-old, many times what we have noticed is it is the girl's parents who complain when they are against a relationship, then they go and complain. The impact is the boy is charged with a criminal charge of, say, kidnapping or maybe rape or something, and the girl is sent to an institution if she does not want to go home. So, what is happening? The whole life is disturbed, he is has a criminal charge and she is in an institution. Everything, their right to education, the right to development, right to further, everything is gone. So, this is another aspect in POCSO which we need to look at. And you asked about less of low conviction rate.
Yes, ma'am.
This is another reason for low conviction rate, because when the girl, she is no, it is a consensual affair. When she goes before the court, she does not talk against the boy, and again you have no conviction.
Yes, ma'am.
So, this 16 to 18 years we need to relook at. In Human Rights Commission, Law Commission, judges in various courts have also said this, but till now they feel that we should not reduce the age, but maybe we give discretion to the judge. But then what happens? The number of cases increase.
Yes, ma'am.
So, you have more burdens on the court, on the forensic labs, on the criminal justice system, which is actually not very suitable for children. Our criminal justice system is a very harsh system.
Ma'am, following up on the same topic,
Yeah.
over the past decade, POCSO has evolved significantly,
Yeah.
from fast-track special courts to the recent NCPCR guidelines on support persons and witness protection, yet implementation remains uneven. From your perspective, what is the most critical shift in thinking or practice that a teacher, ASHA worker or PRI member can adopt immediately to strengthen POCSO implementation at the grassroots?
So, teacher is another person who can make out whether the child something, there is some behavioral change in the child because of the abuse, the marks are suddenly gone down, the grades have suddenly started failing, or he has lost his concentration, he can't understand what is happening. So, this teacher can find out what is the behavioral changes that are there in the child. So, and there are guidelines for teachers, that teachers must be trained to understand how to help a child who is being abused, what to do and where to go. And this is one of the guidelines of the NCPCR regarding teachers. So, that is one aspect. The other thing is that ASHA workers, Anganwadi workers, they are also as I mentioned to you, community workers who are in close contact with the children and the families also, even mothers also. So, they also come to know about the behavioral changes, and they. So, first thing we should do is train all these workers under POCSO, mass training should happen to them. Then you have this support person issue. The support person is a link who helps the child psychologically, emotionally to you navigate the criminal justice system. So, I feel that ASHA workers, teachers and Anganwadi workers, you cannot make them support persons because it is a full time job, and along with their jobs they will not be able to handle it, and there is a lot of confidentiality involved in it. They can be impaneled as per the guidelines that are given in the law, but I personally feel what they can only be used as is creating awareness, doing some kind of a personal training for the children, and one thing they should always be told, it is not the fault of the child, and we are here to help you, and we can see to it that the person is going to be punished for what he has done to you. See, there is a e-box in the NCPCR, you must have been aware of it. There, if any child who has access to it can click the button, then there is an animated film on what is POCSO and what is abuse, and then they can make a complaint there also. And then you have the special juvenile police unit, you have the police in the police station who can file an FIR. And maybe you can take the help of NGOs, counselors there that are available. Yeah.
Yes, ma'am. So, ma'am, now regarding CWCs, ma'am, CWCs and statutory guardians struggle with heavy caseloads and trauma sensitivity. Beyond just legal compliance, what systematic shifts, whether in training or awareness, do you believe are essential to transform CWCs into proactive, child-centric bodies that can genuinely advocate for a child's best interests?
Child welfare committees under the Juvenile Justice Act are such important bodies for protection, care, restoration of children in need of care and protection. And there are huge number of children in need of care and protection in our country. And who has to look after them? Child welfare committee.
Right.
Now, child welfare committees are not statutory, are not full time bodies. They should be full time, structured government permanent bodies that are there, but they are not. And their workload is full time, day and night, 24 hours. But in practice, it is not very easy. So, we need to have full time and full time CWCs that are there, trained CWCs with infrastructure. They do not have proper infrastructure, no proper funding that is there. I think salaried CWCs, full time CW with good infrastructure and training, doing such an important job, of such vulnerable children, and who is at loss with these part time bodies? The vulnerable children. Trained bodies, full time bodies, salaried bodies should be members, should be child welfare committees, because they are doing very important job. And such an important body, it is a sad state of affairs. We need immediately full time, trained, good infrastructure, child welfare committees, salaried. Okay.
Definitely.
Thank you so much for sharing your insights and experiences about this. As we come to the last question of the podcast, we just wanted to ask you that there are a lot of families who end up dropping cases because the cost and instability involved. What can PRI workers and frontline workers do to help provide interim support and ensure that a child actually receives the benefits that they need?
Yes. See, once the trial starts, if they have got the courage to go and file the FIR, and the FIR is investigated properly by the police and it goes to the court, the family needs support from the community, from the society. This the frontline workers can very well help them. They may need, see, many times it lot of cost is there, going to the court, traveling to the court, and they may lose their wages on that day if they are daily wage workers. So that time the Panchayat Raj member can be of a great help. Anganwadi workers and the ASHA workers may arrange rations for them, perhaps through the Panchayat Raj institutions. They need rations for that. They may need some kind of an interim financial support, and maybe they need some counseling also, that somebody is there with them, that emotional reassurance that somebody is there with them throughout. So that these workers can help them in doing it. They can also see to it that the child continues the education, because many times the child drops out, and that is that time also, once the child drops out, it is very difficult later. Many times many families relocate also. So that time also, in the other area where there are ASHA workers, Anganwadi workers, Panchayat Raj, they can help them there in relocating, because, or they can help them here also in seeing to it that all those comments that they are passed, they are not affected by it, because there are all sorts of people all around. I remember that you know, it is very difficult that people say, no, don't go, you have to the courts and the police station, it will go on for years and years, because many of them are not aware of the child friendly courts or something. Oh, you will get a stigma on the child, and it must be your child's fault, don't go to court, and your child will never get married. No marriage proposals will come to her. So all these kinds of you know, comments are passed. So these workers can help them, you know, face all of it. So this is the kind of interim support that they can give.
Definitely.
Thank you so much, ma'am, for this insightful discussion, which helped us move past the legal language to honestly examine the challenging realities of how POCSO operates in practice. The ongoing problem of last mile failure in POCSO cases, where a strong legal framework breaks down during the trial due to systemic gaps, witness hostility, and socio-economic pressures. The really concerning statistic of an 89.64 acquittal rate in cases with hostile witnesses shows a significant failure on part of the state to safeguard child victims from intimidation and family pressure, instead of suggesting that children are not trustworthy.
The path forward requires trauma informed justice, better implementation of witness protection, and truly child friendly court environments. What happens outside the courtroom is just as important. Helping a child feel safe again through regular mental health care like trauma counseling and ongoing support, ensuring financial stability with prompt compensation and rehabilitation, and aiding in social reintegration, making sure that the child can go back to school and community life without facing stigma, isolation, or having to make difficult compromises.
Can I just add one last word?
Definitely.
Definitely, ma'am.
All these workers and all of us must remember one thing: always consider the best interest of the child in all situations. It's not our best interest, not the best interest of the society, the community, the family, the parents, the school, the teacher. It's the best interest of the child always. And if all of us, all the workers, all of ASHA workers, Anganwadi workers, teachers, and Panchayat Raj institution members, if they consider that the best interest of the child has to be kept foremost, then we can see to it that the child is safe and the child is taken care of.
Definitely.
Okay, thank you so much,
Thank you so
ma'am.
much, ma'am.